the first to know Nsem-Pii TV.
Yebusuafo mama kwa baba Nsem-Pii TV so ye kwa kopie mu ewo high court na high court na heat ni na akwakodi because even speaker of parliament during the swearing in or ka say sa 4 constituencies electoral commission for declare Emma the new patriotic party parliamentary candidate after high court and earlier a catch on some recall 6 constituencies so 4 Supreme Court a quashes decision so omukotie mandamus application with the National Democratic Congress as a party to that suit, Speaker of Parliament say on swear some members of Parliament elect and as a parliamentary candidates in because omasem no edaso ewo court. Now pursuant to that and the High Court a person almost fast track process say na ya almost disenfranchise it and I say do not disadvantage any form of constituency in the Republic of Ghana. So omubenya omo representation in parliament. In Tisadia, January 4th, and then year 2nd. By January 4th, now the High Court had a decision on mandamus application. Ebema the Electoral Commission the necessary authority now to go and recollate and officially declare the winners of these constituencies now. Sa to me and no na arguments na ashase na endra ye the ruling justice in Japan e de bae or throw out lawyer Edudzi argument against obetie mandamus application because according to lawyer Edudzi say endra ye kan or say say the new patriotic party new legal council there's some the bar a election petition, not a mandamus application. But lawyer Gary Nimako so can say the acquire the afason because the Electoral Commission in view of Juma and gazette result into any election petition and what assembly is on the bar or more ba ama court and ama home quine say even though election ironing December 17th tribunal or Monsama the Electoral Commission the necessary authority, the necessary legal backing on Betimedia Court, Aquaco every omejuma in these said constituencies. It's Supreme Court did ruling by for 2 constituencies or catch Electoral Commission say omunko regulate. But for this particular 4 constituencies, afeno omoye the omusansutie mandamus application with the National Democratic Congress omo legal party as omo legal council as a party to this suit. Now by January 4th, court determined say Electoral Commission and Samsung could recollate non-determined the official winners of the election in these 4 constituencies. In the end, you call parliamentary candidate of the new patriotic party argument among advancing a home report after preliminary objection by lawyer Edudzi was thrown out of court. Now, Justice Forcing Japan is hearing the applications brought by some NPP parliamentary candidates from constituencies such as Okankwe Central, Ablekuma North, Techiman South, etc. Enti Tema Central and so Ekaho. Enti Okankwe Central, Ablekuma North, Techiman South, and Tema Central. So our report one fact Tema Central and can say Tema Central account because of report on Ebi Bright and Dra Now, parliamentary candidates for some approval beyond reasonable doubt with evidence said presiding officers of these constituencies collated sentence had the opportunity to complete their work at the coalition centers. And some prove beyond reasonable doubt with evidence a support to claim say ampa omenya the opportunity to complete work. Now one of the evidence lawyer Gary Nimako advance in court evidence of during declaration in Tema Central nipa okura A4 sheet a kind ye a determine who is the winner no on no any presiding officer or no any electoral commission returning officer for that coalition center or what the official capacity so be declares a result. Way one of the major advanced arguments lawyer Gary Nimako also making in this mandamus application a be call ahead as quiet akɔkyerɛ sɛ ampa say the court emma easy for nkwan emma mo complete your way. Another work and so the voice of Deputy National Communications Officer Malik Basin Tele, the voice will not say his problem is not with the police officers, his problem is with the EC returning officer. So pill or be declare ama ebi bright say NPP form pa omunko advance your argument in court. Also a sign of intimidation, a sign of forceful pressure on the returning officer, lawyer Gary Nimako, advance, especially for Tema Central. The learned counsel for the applicants, Gary Nimako Mafu, is arguing for the exercise of the powers of the court to compel the Electoral Commission to fully collate and declare election results in the said constituencies of the applicants. According to lawyer Gary Nimako, sir, 4 constituencies we Electoral Commission for NBA omejuma inti court no compel the Electoral Commission no omonko complete omejuma in these 4 constituencies. Justice Ejapon, a newly constituted panel of the High Court, is hearing the applications after humbly dismissing the objection to the jurisdiction of the court raised by the National Democratic Congress through its counsel, the learned Godwin Kujo Edudzi Tamaklo. Inti sa argument we sa statement we ye repeating them repeat. Justice Ejapon etie Godwin Edudzi Tamaklo, legal counsel of the National Democratic Congress. The court has the jurisdiction to hear this mandamus application. Now, what is interesting is the Justice Atuguba Bukukra supported the claim. Say, as far as the Electoral Commission for the gazette or more results, the court has the powers to compel the Electoral Commission to complete its work according to constitutional matters. Yedruwa said, "Sir, argument was also advanced by Justice Ejapon. Time out or dismissing the preliminary objection of Godwin Edudzi Tamaklo." Now, dismissal of the objection. The High Court, General Jurisdiction Division 2, presided over by the learned Justice Fortune Ejapon, prior to hearing arguments on the mandamus applications, dismissed this very morning, that was yesterday, so I report to 8 p.m. yesterday, the preliminary objection raised by the learned counsel for the interested party, National Democratic Congress, Godwin Edudzi Tamaklo. The learned justice, who rendered his decision in a courtroom, bursting as it seems, raised that supervisory powers of the court lie against the Electoral Commission. Justice Ejapon held that apart from a petition which comes alive upon the gazetting of election results, judicial review lies, as well as other judicial remedies against the decision of the Electoral Commission before the gazetting of election results. Justice Ejapon relied on authorities including the constitutional textbook of Professor Atuguba, Dean of the University of Ghana of Law, on judicial review. And to say you can Eliano, Justice Ejapon can say easy for and call ahead and gazette or more result. The Electoral Commission can be compelled by a court to complete or more exercise. And Justice Ejapon held that apart from a petition which comes alive upon the gazetting of election results, judicial review lies as well as other judicial remedies against the decision of the Electoral Commission before the gazetting of the election result. Assembly there, Nsem-Pii and Nsem-Pii, Justice Ejapon, or Hop, and or the two. Or also the two will be the learned justice of the court Per the foregoing, held that the jurisdiction of the High Court to supervise the Electoral Commission is well founded, as the court respectfully overruled the objection of Mr. Tamako. The ruling of the court, according to Justice Ejapon, applied to all other applications similar to that of Nana Ekwe-Free, which are all mandamus applications. It is a matter where it has judicial precedence. This is not the first time mandamus application in the court of law. And Justice Ejapon relied on these judicial precedents. And I'll mention Nana Ekwe-Free case via mandamus application. This same issue of non-gazetting of the Electoral Commission happened, and the court compelled the Electoral Commission to complete its exercise. This is not the first time a mandamus application has appeared in court for Justice Ejapon to rule on the matter. Now, this is the second time the court is hearing the mandamus application of the NPP parliamentary candidate. In the first time, it was 6 constituencies. Afi A4. 6 now was challenged by the National Democratic Congress Legal Counsel Godwin Edudzi Tamaklo, and it relied on an important basis of natural justice. Say, or no, or an interested party in the suit, was not heard. The same thing can be said to other parties of the political divide, other parties, but do they have significant numbers of votes to be called an interested party? Or the number of voters the National Democratic Congress had, they were a sure interested party in this matter. Now, I say court, and I said the learned judge or Maho Point, etie Dombeka, and Sana or the ruling about said the Electoral Commission should go and recollate results. Because one, early on, and Sana collating of results in easy, whether fake, false, or pretense. Sa declarations a court it be called the National Democratic Congress. It is a court in the case of recollate na adani flow sema. Of course, as an interested party, na case of Mahon Emobutikuti, Intienkuti, Dintia, sa mandamus application. This is the second time it is being heard by Justice Ejapon. And no, every Supreme Court, ruling on the buyer, said the High Court judge in the first suit. Aid in his ruling or catch Electoral Commission say could recollate these 6 constituencies without hearing an interested party that like that of the National Democratic Congress. Where a report, same report titled High Court Judge aired in orders to the Electoral Commission to recollate votes in 6 constituencies. Certiorari application upheld in part. Into certiorari application of the 2 and then na Supreme Court for editum. There were aspects Supreme Court did not agree with the certiorari application. And no, and then some part now you be making it available in this report. Part the Supreme Court are agreed with the certiorari application, and also you be making it available in this particular report. Senior conformity DNT this mandamus application. This is the second time it is being heard in the High Court. Now, if this time it is heard with NDC as an interested party, will NDC have the audacity, the effrontery, so also Supreme Court and as a court of appeal to seek any form of remedies and I said to allow the Electoral Commission to go ahead and complete its exercise. Should in case by January 4th, Justice Ejapon agree say allow the Electoral Commission to go ahead to recollate result in these 4 constituencies. In the Supreme Court for a sensible case back to the High Court. The Supreme Court presided over by Justice Scott Gabriel Poamai in a unanimous decision where a 5-0 has upheld in part the application brought by the National Democratic Congress. You know what is surprising is that this time there was no cause of alarm. There was no issues of bias by the Supreme Court. That time unanimously agree with that of the National Democratic Congress. We've seen in the past go ahead accuse the court from unanimous FC say agree unanimously against the National Democratic Congress. This is one of the rare circumstances Supreme Court unanimously agreed with the National Democratic Congress. Sir, chastising, bastardizing of the court after that unanimous decision. This time, it was neither heard anywhere nor cause for alarm was raised. Now, let's go to why court unanimously agree with the legal counsel of the National Democratic Congress. I say against the ruling and orders of the High Court, General Jurisdiction 13, compelling the Electoral Commission to recollate and declare votes in 6 constituencies. The Supreme Court was constituted by Justice Puamai, Professor Mensa Bonsu, Gaiwu Ejay Frimpong, and Anthony Kofi. The Supreme Court held that the NDC should have been given a hearing in the mandamus application brought by some NPP parliamentary candidates. It's the fundamental case the National Democratic Congress and the court said they were not given an opportunity to be heard. The court relied on the famous Awuni versus Wayek and held that the failure of the court to hear the NDC was violative of the right to be heard. That is their natural justice right of audi alteram partem. Now, the court ordered for the question of recollation pursuant to the order of the High Court in Okankwe Central, Ablekuma North, Tema Central, and Techiman South constituencies. In the out of the 6 courts ordered for the question of the 4 of these constituencies and in the High Court to be reheard again by Justice Ejapon. Now, the court in the voice of Puamai JSC further ordered that and Ahafuano North should stand and the applicant be allowed to file and be heard on the mandamus application. Bias of the High Court. And the court did not agree in part with the Setorara application. Or say the court held that the evidence offered was not enough to support the claim of bias by the High Court judge. That notwithstanding, the court ordered for the hearing of the mandamus application by the High Court differently constituted. The constitution of the presiding judge for the High Court case on this mandamus application, even though did not agree with the mandamus application of did not agree with the Setorara, said there was bias, but for the benefit of peace, or reconstitute court on this particular mandamus application. Now, full reading the entire Supreme Court judge, or full reading of the case at the end, just to provide the audience, just to provide societal interest, public interest in this matter. The entire full reading, because normally Supreme Court judges full reading, sir. It's reason full reading, and also the Supreme Court, after hearing extensive argument to both sides, retired to chambers to deliberate on their decision. The bench took over 2 hours in deliberations to reach their decision. The Supreme Court, in the voice of the President, Puamai JSC, said that they were minded to read the full ruling of the court to prevent misrepresentation of their ruling owing to public interest in the matter. Because heated elections, a lot of people are interested. A lot of people are following. A ban is saying that leave a vacuum, a lacuna. A lot of making a lot of misrepresentation and needing Justice Palmer reading the full ruling at the hearing of the public. Say there will be no form of misrepresentation heading into the case. Of course, 4th January, say ruling from the newly constituted High Court judge and a councillor. Obetuma trust say Nsem-Pii TV. Yeah, the Bebremo. Near follow keenly the reconciliation, the differences between the first declaration by the Electoral Commission. It has now been challenged in court. Now, they are compared who takes these 4 seats to complete the constitution of the new parliament for president-elect and the new government heading into 2024 to 2028. Wait, any full report on hearing of mandamus application by the new Patriotic Party parliamentary candidates after the preliminary objection of the National Democratic Congress Legal Counsel was then dismissed from the High Court. And